And so, and in court, we will use, sealing procedures, and then the information wouldn't be disclosed in any other public forum. And any other...
And I just want to make sure going forward that I'm not agreeing to this based on, and so that you know what my intentions are, because I am going to go back and ask her to unseal those documents, because not all of them contain proprietary, top secret, confidential information. So we will be submitting a motion to unseal the documents, because a lot of the information is totally unrelated. Some of it is unrelated to Insight, period. Not unrelated, but not Insight information at all. Like it was given to the EEOC, like the position statement.
Absolutely.
So those things should not be sealed.
And one of the things we can talk about today is how to make that as easy as possible for the court. My goal is always to make things as easy as possible for the court, because they're so busy, and we give them the best information we can to help them make their job easier. And one of the things that's really going to help in that instance is if you don't have a copy of John's email that he sent identifying some specific information, I can get you one. And if you start there and look at those things,
I can do that if you could give me a copy.
I can do that. I'll have my assistant print it up and bring it up for us, because I don't think you and I are going to disagree that some of that information is not confidential, but because we didn't have another way to remove it from the public docket immediately, considering that it had some information we consider protectable, right? It was just the mechanism available to us to do it. Okay, so I think that as part of our meet and confer today, we can definitely demonstrate to the court that we're coming up with some reasonable approaches to this.
Sure.
She will appreciate that.
Okay.
Copy of email. Okay. And then non-disclosure of confidential information would also apply to, like if you were seeking employment in the field, the documents wouldn't be disclosed, or the information wouldn't go to any prospective employers.
Yeah, I just wouldn't do that. That's not who I am.
So if you disagree with that, typically what we do is we have a provision in the protective order that says you contact us in writing, within a certain period of time upon your determination that designation doesn't work, and then we would respond within a certain period of time so that we can do our best to resolve the dispute. Is that something that you're good with? Okay.
Love writing.
Yeah, well, it makes a nice trail, and it also makes it official. And then if we, in the course of our attempts to resolve it, we can't resolve it, at that point is when we would escalate it to either the court or the arbitrator to resolve it. And that's a pretty standard practice generally. So I will tell you, in my experience, they don't like it much. That's why they put the onus on us as parties to try to figure it out. But they're used to resolving these are discovery disputes, basically. And there's some provisions in the rules for how to handle that. Each judge or arbitrator handles it differently. So what we would do is come up with our stipulated protective order. We submit it for approval by the court or the arbitrator, and then if they had specific procedures they wanted us to follow, like faxing a letter explaining our positions, and sometimes they do that. Okay. So, but we would keep our stipulated protective order somewhat in general terms so we can accommodate the court or the arbitrator's request. Okay. And the final piece of information that is typically addressed in protective orders is what to do if, for instance, you produce a document to us that contains a bunch of bank account information but fail to stamp it confidential. We understand that sometimes happens in cases with lots of documents, and inadvertently we may do the same thing. The rules provide for ways to protect inadvertent disclosure of information, and so we typically include it in our protective orders so that if something is produced inadvertently without a confidential designation, the party producing it contact the other and say, hey, whoa, I made a mistake. This is supposed to be stamped confidential. And then at that point, going forward, it wouldn't be disclosed without following our procedures. And that would also trigger the dispute resolution if the other party said, no, wait a minute, that's not confidential, then we'd follow our established procedures.
I'm just trying to figure out, how do you inadvertently disclose something that is confidential?
I'll tell you. I can give you a bunch of examples, actually. It happens in cases with large amounts of documents. If, for example, a 5-page email chain references a customer's specific name or account number on page 3, but somehow that's just not redacted, or there's an error made in redaction, it just gets sent over. Now we've got a piece of confidential information out there that shouldn't be. And if it comes to our attention, we say, oh, it's really, a protective mechanism to make sure everything we've agreed should be protected, is protected in the event of human error.
Okay.
That's really what it is.
Okay, that's fine, but I just don't want any information being published that should not be published, and it should not be published, and you do it anyway, and then by stipulation, you can come back and say, oh, we didn't mean to release this. So.
Right, and I think you raise a good point, because that's exactly our goal. We don't want things out there that shouldn't be out there. And we go back to our good faith basis. We work in good faith to make sure we're handling our cases and we're honest in how we do that. And that's my practice. If a mistake happens, we address the mistake, but we abide by the rules of our protective order to make sure the information is protected. And so inadvertent production is just something that's been incorporated more and more into the Federal Rules of Procedure because of cases involving electronic mail and we call it e-discovery. It's massive information, massive amounts. And so we want to make sure that we understand if it's inadvertently disclosed, it's not a waiver of protection, it's something that we're going to remedy, and that we'll follow our stipulated procedures to handle it.
Okay.
So
we want to make sure that that's just not something to allow you to, misuse of the stipulation or whatever.
Oh, absolutely.
Just like you said, I don't want information that shouldn't be out there. Say, for instance, information that's gotten unlawfully, invasion of privacy information type of things, and you put it out there. Oh, we didn't mean this to go out there, something like that. So I don't want it.
Well, and the first step really is, if we're talking about discovery obligations going forward, it would be us exchanging information with each other. And so before it gets published anywhere, now we have a unique situation because of the way our case sort of started out. So it's slightly different, and we'll deal with those specific exhibits and do the best we can to nail that down. But if before we publish anything, we tend to look it over carefully to make sure that there's nothing in there, especially with, I don't know if you don't do e-filing, right? Okay, but there's a little checkbox you have to do when you do an e-filing to make sure that you understand that if someone's social security number or bank account information or really sensitive information is included in a document, you do redact it out. So before we file anything publicly, we always double check to make sure that stuff's not there. And so in good faith, we would basically hope that you would be doing the same thing to make sure that stuff's not present as well. So typically what we do is a stipulated protective order that we submit to the court, and that's a document that we sort of work on collectively. So it's a lot of back and forth in getting the language right and how we to reflect what we've agreed on. Right. So without email, that'll probably make that a little bit of a longer process for us because there'll be some mailing back and forth. But one party typically takes the lead in drafting that up, sends it to the other party, and says, hey, let me know your changes. And they usually do that electronically with like track changes or showing